Professor Yoram After. So great project. Can we move on to some causal analysis here? What would explain this move over time globally to broadly more friendliness to investors? This has been an old tussle between the sanctity of property rights and the sanctity of sovereignty. Ever since after the Second World War, there was always this balance between these two principles. I could speculate two things. First, this is just another manifestation of growing bargaining power for investors. They'd always love to have property rights superior over sovereignty, so they've just been able more now to get it their way. And the other explanation is maybe it's because investment is more fragmented these days. It used to be in the 60s or 70s, and only major big multinational companies would do this, and they tended to resolve problems if they had as an intergovernmental thing. This would be informal. They would go to their government. In the United States, it would be formal, actually. But in other governments, it may be informal. They would go to the government and say, I have a problem in that country. Why don't you, let it the interstate, turn it into an interstate thing and resolve it. But now when you have smaller business engaged and a greater number of countries that are engaged in this, maybe this doesn't work anymore. Dana? I understand that the approach of the Israeli government, as you laid it out, was that a bilateral investment treaty is a signal of how prestigious is our legal system. We don't need this because we're good. Maybe I got it wrong, but I'd like to point out that obviously in the European Union and the United States there is no such issue. And the reason there is a conflict over this tribunal is because, these panels, is because they have different perspectives on where do property rights fit in their societies. And that's because they don't trust American judges to call these issues in Europe. Not because they're not honest professional. It's because they have a different idea of how superior these issues are relative to other things. And finally, Aryeh, you're raising an excellent point, I think, when you're bringing up the energy sector. And the point is that it's not the same for all sectors. Nobody should be surprised, and I'm not sure a single Texan was surprised that this is high politics. Energy is always very political. You've got the idea of protecting these gas installations. Our daughters and sons are going to be there for what? For their money? So this is very, very political. Obviously, there would be no other way, would be, of course. So there's no way property rights would be superior in such an issue. So, but it does raise an interesting point that some sectors are by their nature much more political and would need a different arrangement. Thank you.
First, I would like to beg to defer to Professor Reich on the energy and gas. To put it bluntly, I think most what you said are wrong, are not correct. And I'm dealing with this for the last 6 years. I'm from the Chazan Center in Van Leer Institute. But the main point is, I think, regarding this meeting, is why is government allowing ISDS? Why do we have ISDS in the first place? How it became legitimate for corporations to demand that the public pays or insure them against their own risk that they choose to take. And I think this is the basic point here.
If both countries agree to the ISDS, how can it be that when investors want to come to Israel and invest with gas or other things, the country can say, and my question goes to you, Aryeh, that we are going to add more taxes, you're going to pay less. I don't understand that.
One of the issues presented by Yoram was the variation of the ISDS phenomenon across time and across countries and regions. And my question is whether it is related also to the type and nature of the investment. Now, Aryeh touched upon a little bit, and you also did refer to it, but I think it will be very interesting to examine this issue a bit further.
Okay, well, thank you very much for many comments. I won't be able to respond to everything, but I'll do my best. Ari, I totally agree with what you said about the WTO experience. I agree that the appellate body has done a wonderful job in terms of uniting or unifying the jurisprudence, and I think the appellate tribunal of the ICS would be able to fulfill a similar role, but only with regard to one treaty. So you have to bear in mind the idea is to have one of these appellate tribunals for each EU treaty. So at the moment we've agreed more or less on 4, but that could become many, many more. So it will never be as unifying as the appellate body of the WTO.
Unless it goes on to this multilateral.
Unless it goes on to this multilateral, but I don't see that happening in the next 10 years, but maybe you're more optimistic than I am. A brief side note with regard to the WTO, if you look at the whole discussion with regard to the renewal of this one Korean member of the WTO, I think that makes you think twice about the non-politicalness of an appointment like that. Not to say the very political position of such a judge and the motives that play when you appoint someone. So this is not entirely, an impartial, objective decision, but that's another dispute. With regard to the public criticism against the World Bank, I had a quick look. I have put in footnotes referring to the public consultation document with regard to that point, so it must be there. I can also say from my personal experience, I was an advisor to the Dutch government, and in stakeholder meetings there, ICSID was named together with the World Bank. I was an expert in the hearings before the European Parliament. Again, there, European Parliament members refer to the World Bank in the same sentence as part of, ICSID being part of it. I'm not saying they're right. I'm just saying this is in the minds of people. It does play. With regard to ICSID, you're absolutely right. So ICSID, the role of ICSID would be essentially a secretariat without a capital S. So it would be very, very, very minimal. And I also agree with your point that if the losing party pays everything, well, it raises the stakes. So it would just become more expensive to make a mistake, whether you're a state and you violate somebody's rights, or whether you're an investor and you bring a frivolous case. So I agree with you. I also agree with you that it would be a good system. I'm just saying the people who think that this will make it cheaper for the state are wrong. And in that sense, the criticism is not completely answered. Shai, moving to your comments, I agree with you. Several matters are addressed in private arbitration. I've read Murray's proposal on making it more cost efficient. My point is rather that if it's not in the investment court system as it is drafted now, you cannot transpose these rules. So if it's not incorporated, it doesn't, it won't matter. And you can say, well, there's no need for deviate, but I would say that this train has left the station. We are already deviating, so you'd better take that kind of thing on board. I'm aware of the pledge. I'm aware it's endorsed by major arbitral institutions. I'm more skeptical. I'm just a black letter lawyer. For me, it's the same level as commission press releases saying they will do great things for diversity. I will believe it when it happens, and if it's not binding, I very much doubt that it will happen. I see your point when you say, well, why not respect the molding of the agreement of the parties, the arbitral agreement? But again, I think we've passed beyond that. You refer to LCIA, the SCC, etc. These don't even enter in the debate at the moment. In the proposal, it's ICSID or the PCA, and then I think with the current proposal, which is not whether it will exist, but when and whether can we still tweak something. I think we have to make sure that if we don't agree with this proposal, it is changed and in the proposal, because otherwise it will just fall outside of this particular system, and it will not happen. It will remain good intentions on the fringes. And with regard to the, sorry, I'm very sorry I didn't catch your name.
My name is Amnon Portugal.
Well, and thank you very much for your comment. It was not even mentioned at me, and I will not enter. I know the energy debate here in Israel is very sensitive. Even people on the plane talk to me about it, so I will not say anything about it. But just in regard to the more theoretical point, investors are not supposed, and the system is not developed to protect investors against the business risk. Several tribunals have explicitly and repeatedly said so. This does not protect against business risk. That is something investors should carry. What they are protected against is unfair treatment or compensation, expropriation without compensation by the government, which I would say is something different than business risk more general, which indeed they should not be compensated for, because that's what it means to be in business. Thank you.
So Thank you for your questions and comments. They're all very good, and most of them I cannot answer because what you're asking about is really what explains the variation in the content of the treaty or the change, and this is what Tal was calling causal analysis. And I'm not there yet. I have high hopes for the summer, so hopefully I'll have some answers to these questions next year. But I really wanted to take the time and actually comment on the comments and also ask Dana a question, because I think there's some important issues that were raised here, and I think both discussions came to these issues from the right, and I'll try to come from the left to make things interesting. And starting with Ari, so what Ari was saying, or at least implying, is that investment treaties bring more investment, and that's why they're a good thing. Now, I think we can take issue with that, because if you look at econometric studies, I would say that at best, results are mixed. We don't really know that investment treaties bring more investment. It's debated. There's no consensus in both different types of research. We don't really know that this is the case. Now, what we do know is that investment disputes are very costly for governments. And in this sense, the calling for signing more treaties, whether with capital importing countries or capital exporting countries, I think is questionable. And then the question for Dana is, which I'm really curious about, is who in Israel, in the Israeli government, and why thinks signing more investment treaties is a good idea? Why signing a bit with Japan at all? I mean, why signing a bit with South Korea? What's the logic here? Since we actually see many governments actually now retracting their treaties, denouncing the treaties, renegotiating the treaties. Some don't negotiate at all. And Israel, as many other countries, is going in the other direction. And in some sense, that shows you what we saw in my research, that is a gap between the discourse and what governments do. So, academics and experts tell governments this is a bad idea, and still you go on and sign them. And I wonder why. And that brings me to Shai's comments. And you say that the system is great. I mean, could change things here and there, but overall, the system, the ICSID and everything works well. And I would like to make 2 points on that. First, again, as the non-lawyer in the audience, I can say that. It doesn't matter who loses and who wins. Lawyers make money out of this. It's the lawyers and the arbitrators are benefiting from the system big time. And again, it doesn't matter if the state wins or the investor wins. Those who do the work for them are actually benefiting from that. So in this sense, again, lawyers have an interest in keeping the system going. Again, not talking about you personally, but in general, we know that arbitrators are making. What? Right. So again, we should keep that in mind when we have these discussions. And then the second point is that I think a lot of people will disagree with you if we just take some of the prominent cases. Let's take the Philip Morris against Australia, right? So we have a tobacco company going after governments for trying to convince the public that smoking is a bad idea, right?
And losing.
Right.
Jurisdiction.
But they're going to.
People coming from left always mention that there was a suit. They never mentioned
Right.
that it was dismissed.
But we expect to see more. I think Philip Morris did not.
Jurisdiction.
Philip.
Which also, the private arbitrators are told to be biased in favor of jurisdiction, because that's how they make the money.
But Arya-
Nevertheless, they dismiss. They throw out claims one after the other against their own interest.
Okay, we made things interesting. That's good. I guess this is not the last claim by Philip Morris of governments. I'm pretty sure. So this is not a done deal, and this is going to, again, lawyers will make more money out of more suits. So I think. There are many problems to the system as it is, and I guess my own opinion is that it does need reform, and the system is not working well.
First of all, to Aryeh, I want to mention, as I mentioned briefly before, but that indeed the policy in Israel is changing. We have the policy in the past was to sign agreements, BAT agreement with not so strong countries, maybe developing countries. that where the chance of Israel being of a claim being brought against Israel was smaller, and the incentive was more to protect Israeli investors investing in the other country. But the trend, not the trend, the policy has changed. It has changed in the past few agreements. It's mentioned actually explicitly in the last government decision with regards to the Japan, to the negotiation with Japan. The policy has changed. Now Israel is negotiating with stronger developing countries. Sometimes, as I said, in the course of more general FTA negotiations, which have their benefits.
Free trade agreements.
Free trade agreements, which have their benefits aside from just the investment chapters. So indeed, it's changing, and the thought process in our team, in the government, is also changing. This is why we changed a bit we're modernizing the model. We are taking into account different trends and different awards that have been taken. We're very, as was meant, contrast to what was said by Professor Haftel, we are very un-narcissistic. Mm-hmm. We're trying to learn from everything, every award that, most important awards that have been given against other countries. We are learning from every negotiation and every different agreement that we see that comes into force or is negotiated, and etc. And so this is for Aryeh. Now for Tal, I think?
Tal, yes.
Yeah. Maybe just to clarify, in my presentation, I did not mean that the fact that we have an open court system is one of the motives of having an ISDS mechanism or changing the ISDS mechanism. This was just one of the, as I said, one of the preliminary thoughts that we've also seen, or I've also seen, in some of the criticisms against the ISDS mechanisms in the EU, the criticism in the EU against the ISDS, against the ICS itself, which still calls for a lot of criticism in the EU. So this is just one of the thought, one preliminary thought. Is it necessary if you accumulate all the reasons that I mentioned? But most importantly, saying that this mechanism is still in its early stages. We have to see how it develops, and then to see if it actually works better for us or not. If maybe we can fix some of the criticisms, as was mentioned by Shai, maybe through different mechanisms, maybe something else globally will emerge, and we try to take part of it. And also, just to the comment from Mr. Portugali, as was said, the intention of this agreement was not to protect investors from commercial risks, but from non-commercial risks, from unfair behavior by the government. And this is a point that we stress in every negotiation. It's very well known also in our negotiation, in our position. And now to Professor Haftel, you asked who thinks that it's good to sign BAT agreements. Well, this is I'll try to answer, as much as I can. As I mentioned also, there are a lot of reasons for why you negotiate agreements in general, with international agreements in general, but also especially trade agreements, economic agreements. Sometimes there's political reasons, sometimes there's other maybe broader economic factors, as I said, if you negotiate FTAs. So, and in some of the cases, it's decided by the higher instances in the government, by the prime minister. So there are a lot of reasons. Sometimes I can't answer very specifically, because I'm from the Ministry of Justice. Usually I counsel to these negotiations. It's not our decision to start start negotiations. And last, to the question from the student, Hila, from the student in the audience, you asked how, if we have ISDS, if we have those BATs, how is it possible to change the conditions for the investor? So I just wanted to say that in general, and also in our policy as a government, but in general, the BATs are not meant to stop the government from being able to take any regulatory step from now on, from the minute they're signed and onwards. There is still room for the government to take action, to take regulatory steps. There is still a regulatory space. There is debate on how large, as Professor Haftel also presented, how broad this regulatory space is, and should it be broader? Should it be narrower? And this is also part of current negotiations and current debates. This thinking of should the policy space be made broader? Should the governments be able to be able to regulate more? And but some of the conditions, I can only say as an example, the best example are tax law changes, which have been in most recognized by the tribunals also, that they are allowed as long as they, you could say as long as they don't go too far, but the government's ability to change their tax regime or tax percentage of one sector or another is mostly recognized as possible, depending on how it's done, through what procedure, and what is the consequence. Thank you.
All right. Thank you all very much.